a nonprofit called the Youth Board. Please bear with me today. This is my first conference summit panel situation, so I'm excited but nervous. I have had the pleasure of working on organizing this summit for the past, I'd say like 2 months or so, with public health advocates, California Urban Partnership, and of course Hood Incubator. And on behalf of all of us, thank you so much for attending today. I would also like to thank my 3 panelists, Rodney, Holcombe, Viviana, Becerra, and Evonne, Silva, for coming out. We appreciate you speaking. Also, as a kind reminder, we're going to be taking questions and discussion after the panelists are done speaking. So if you could hold off on anything that is super important until then, that would also be greatly appreciated. So without any further ado, let's get into this. Today's topic for my panel is going to be marijuana decriminalization. And the first thing that I'd really just like to touch on is that I'd like to acknowledge that marijuana decriminalization, it wouldn't be necessary if marijuana hadn't have been criminalized in the way that it did in the first place. Touching on Dr. Flo's presentation from earlier this morning, movements like Jim Crow and the evolution of the DEA are some of the more explicit reasons why marijuana decriminalization is such an issue in the first place. And speaking on it from a youth perspective, I am 24, so I feel like I fall underneath and into that category of youth developers. And now, as someone who works in the children's advocacy world in Sacramento, I feel like I got a very unique perspective on all of this. As someone who is super compassionate about the state of the community that I live in. I don't know if any of you in here are from Sac, but I live in Oak Park right now. And Oak Park is a very historical neighborhood, but one of the things that it has a history for is being underfunded. And I don't like that history. I think it's messed up. As an effort to try and help in all of that, Youth Board over the past 4 months has kind of been pursuing that marijuana tax money. I know we touched on it earlier, about $50 million should be coming to the Sacramento area through this burgeoning marijuana industry, and we're trying to capture some of those funds for affordable recreational opportunities, art and music education classes, mental health awareness, after-school programs, and other youth services that seem to be so lacking in low-income communities and communities of color. And we know that part of that is the war on drugs. This anomaly also extends into the Valley, the Bay, and Southern California as well. And we know why this anomaly exists, as we've spoken about many times today. Systemic racism is often the shadow that follows poverty and trauma. According to the ACLU, African Americans are arrested at rates 3.7 times greater than whites, even though the marijuana usage rates between these two remain relatively the same. And in California alone, there are 1 million marijuana-related cases that are eligible for reduction or reclassification, but only 4,900 individuals have pursued petitions at this moment. And for me, there's just a curiosity that lies around that. Why does that exist? And some of the reasons, there are several barriers that prevent a person from seeking expungement. Generally, time and money are the main ones. Depending on the county in which the crime was committed, a person seeking to clear their record will have to travel to gather their rap sheet, and between legal costs and financial barriers, most people never file a petition. And speaking as a woman of color who has had several negative interactions with police, security, and legal personnel, I can understand the stigma around re-entering a courthouse after having been criminalized in one. We know that the legalization of recreational marijuana in California via Prop 64 back in January has drawn attention to the expungement issue, but there are several other sources we can outlet this problem to besides our local courthouses, public defenders, and DAs. On a current event note, I don't know if any of you are aware of Assembly Bill 1793, but our governor has signed that bill as of today. And very exciting for those of us who have been advocating and working towards an automatic expungement process here in California. This is going to ease that process. We've also been working with Code for America, who is here today, and I'll let her touch on all of that later, but Code for America is also a great national nonprofit that's working on the expungement issue. So really trying to keep in mind for what we're working on this panel today is what push would be required of us and of others to increase the numbers of people we have filing their petitions for expungement and just being expunged in of themselves, and how do we assist those seeking Prop 64 decriminalization? And I would like to now turn over the floor to Rodney. He's going to be giving us just a general overview of expungement and, increasing our knowledge and awareness. Thanks.
Thanks for having me today. It's a pleasure to be here. My name is Rodney Holcombe. I am a staff attorney at the Drug Policy Alliance. We're a national organization that promotes drug policies grounded in science, compassion, health, and human rights. Over the past 2 decades, we've been very instrumental in having marijuana legalization bills, both for medical use and adult use, across the country. We've been quite successful in that arena, and we're hoping to continue pushing the envelope in more states as the years come. We were pretty instrumental in helping to get Prop 64 passed. We helped to draft Prop 64, campaign around Prop 64. A lot of my colleagues put their blood, sweat, and tears into Prop 64, so it's so great to just kind of see where it's come from there. I think I want to start out by just giving you all a little bit of context around what marijuana criminalization has looked like here in California. I know Dr. Flo did a really great job of setting the stage on what that's looked like across the country, but here in California specifically, there have been numerous efforts to reduce the harms associated with criminalizing marijuana, but something that we have to recognize, of course, is that this did not impact the Black and Latinx communities in the way that it should have. But as early as 1975, possession of an ounce or less of cannabis was reduced from a felony to misdemeanor, which is, as I'll talk about in a second, pretty significant. A felony comes attached with lots of collateral consequences, so reducing that really transformed the lives of lots of people. Fast forwarding on to 1996, we passed medical marijuana here in California. That was we were the first state to do that. And of course, in that, lots of folks were no longer being criminalized for using marijuana for medicinal purposes. In 2010, Governor Arnold Schwarzenegger signed a bill that actually decriminalized cannabis possession even further, removing the penalty from misdemeanor to infraction, meaning that a person can no longer be arrested for a marijuana law violation with regard to possession, and instead they were just given a citation or ticket. In 2014, many of you know about Prop 47. That expanded cannabis, gave more opportunities to folks who also had other cannabis convictions. People who had convictions for cannabis concentrates or for possessing cannabis concentrates were able to have those reduced from felony to misdemeanor. And then, of course, in 2016, Prop 64 was passed, and that allowed for numerous people that had numerous offense types, including possession of marijuana, possession with the intent to sell, cultivation, possession of cells of cannabis, to have those records changed, reduced down from felony to misdemeanor, misdemeanor to infraction, or in some cases, completely removed from their records. And something I mentioned before is what we call collateral consequences in the U.S. And lots of people don't really think about this when we think about a person receiving a conviction, but this is a very important component, often more damning than the actual term of incarceration, probation, or parole. But with regard to collateral consequences, just to provide a working definition, these are the legal and social consequences that come attached to a criminal conviction. In California alone, there are nearly 5,000 collateral consequences that can come attached to your conviction. This can prevent you from seeking out great employment opportunities, from getting public housing or public benefits, can lead to very severe immigration consequences, can prevent you from getting occupational licenses, and the list goes on. One of the most bizarre to me was that people who have felony convictions aren't even able to go on field trips with their children. And if you can only imagine some of the barriers that are created in these instances, I mean, you're really just not able to lead a productive life, or you're just really prohibited from leading the life that you may want to. So, I mean, these collateral consequences are certainly something that, you know, are definitely going to prevent people from engaging in meaningful ways. But a lot of states, to address this issue of collateral consequences, have created what we call post-conviction relief processes. Here in California, that can go by a number of names, but essentially a person can have their conviction dismissed or vacated or have it reduced from felony to misdemeanor, and this will reduce some of the collateral consequences that come attached to that conviction. I think what's great about California is that the collateral consequence process here, or the post-conviction relief process here, is pretty expansive. There are numerous routes for people to have their convictions changed, which is remarkable. Lots of other states don't have similar processes, but of course the work still continues. In California specifically, I know it's obviously barriers to accessing expungement for marijuana and other conviction types is quite difficult, but we do know that it exists in a way that it doesn't elsewhere. So of course, like, we know it's good, but we need to just keep pushing that envelope further. But beyond that, in order to get post-conviction relief, generally the process requires a person to either shell out hundreds or in some cases thousands of dollars to a private attorney who will then help them navigate through that process and petition the courts to have their records changed. As we know, most people cannot afford that, so they're relegated to public defenders' offices that can help them with this, or to nonprofit organizations that host clean slate clinics. Unfortunately, those aren't accessible for most people. Those clinics are often very far away from most. They're usually centered in urban spaces, your Oaklands, your Berkeleys, San Francisco, or Los Angeles, but for a person living in Kern County, for example, or a person living in San Bernardino, access to relief can be quite difficult. So we definitely want to think about that as we think about these collateral consequences and about post-conviction, because so many people, even though these laws exist, will never have the opportunity to have their record changed. And so here's a picture actually of a clinic that we hosted in Southern California. My organization has done quite a bit of work around expungement generally, but of course, as mentioned before, really only about 6,000 people have petitioned for Prop 64 relief, and well over 200,000 people are eligible for this relief. So that shows you that after, what is it now, 2 years, not even 5% of the people who are eligible have gotten access. And that's troubling, and that's something that we have to continue pushing for, because, I mean, this is really preventing people from leading the lives they deserve to live. Of course, you know, hosting these clinics is important, but we have to think of more creative solutions to resolving these issues. And so I know Viviana is going to speak to this a little bit more, the recent passage of AB 1793, which will automate this process. That's, you know, transformative, it's remarkable. But one caveat, and I always have to go with the but after we get, you know, good news. These people that have convictions often have other convictions for which they can receive some form of relief. And so although we're automating this process, there are other convictions that may stick to their record, and they will not get the relief from these collateral consequences if they so deserve. And so we have to think about that and think about automating even more processes so that even more people can have access to these remedies. And just, I think, to provide some numbers and just information generally, I don't know how many people are familiar with post-conviction relief, but even accessing a copy of your own criminal record in California can cost anywhere from $25 to $50. And there is a fee waiver process for people who are low income, but I mean, just even navigating that process, it was confusing for me, and I went to law school, and I can only imagine for someone who does not navigate, laughs, yeah. But I can only imagine what that's like for someone who does not have time to actually read through this material, who don't have time to read 60 plus pages of Prop 64 to understand what that process is even like. So, you know, we have to think through more creative solutions to make this accessible for everyone. And I think I'm going to finish up by just providing some tips on what we should potentially be doing to move forward in this arena before I hand it over to my great co-panelists. But public education. Most people don't even realize that post-conviction relief exists. And if they do, they don't know how to access it. So we definitely need to get the word out about that so that people can reclaim the lives that they deserve. Beyond that, California, I will say again, have a lot of work to do, but nestled in Prop 64 were also resentencing provisions, which allow people who are currently incarcerated on probation or parole for marijuana offenses to be released early or to have their sentence shortened. This is the first state to do that. No other state to legalize or to create process for removing or reducing convictions. has thought through resentencing, so that's just not really a thing elsewhere. So we have to really think critically about how we legalize and how we allow people who are currently incarcerated to reclaim their lives and to be released and back to their families and their communities. Beyond that, we need to think more critically about automating these processes. It's great that these processes exist across the country, but California, again, is the first to automate. And of course, that will likely have a ripple effect, but we need to be very clear that people need access, and the traditional routes of going to clinics and driving for hours and going through this several months long process is just not feasible, it's not fair, and we can do something about it. And finally, I think it's important to note, just with regard to the industry, there are barriers to entering the industry for people who have prior convictions, especially drug-related convictions. California, not so much, but in states like Pennsylvania and West Virginia that have medical marijuana programs, there are provisions in the law that do not allow them to work in the industry. And that's just not fair. It's messed up. We have to really create opportunities for everyone to engage in this industry, because as we know, this industry is being built on the backs of Black and Latinx people who've been incarcerated and oppressed for these marijuana law violations. So I'm going to hand it over to my panelists, and thank you.
Good afternoon. My name is Viviana Becerra, and I'm the Legislative Director for Assemblymember Bonta, who represents this beautiful city of Oakland, Alameda, and San Leandro. First, I want to thank you all for the opportunity to speak with you today. A special thank you to Jim Keddy for having me here to speak about a really important piece of legislation, AB 1793. We got the good news last night, that Governor Brown had signed AB 1793. And I know that wouldn't have been possible with my co-panelists here who really dedicated a lot of time throughout the year, and all of you, every single one of you who also dedicated time and coming up to Sacramento to testify at the hearings, sending support letters, and really up until September 30th, which was the deadline for Governor Brown to sign or take action on bills. A lot of you submitted letters of support, so thank you. So AB 1793 by Assemblymember Bonta creates a simpler pathway for Californians to turn the page by having certain criminal convictions for cannabis-related offenses removed from or reduced from people's records. Proposition 64, as you all know, passed with 57% of approval in November of 2016. And it contained provisions that not only prospectively reduced or eliminated many cannabis law violations, but made those changes retroactive. That was probably one of the key components why Assemblymember Bonta was so vocal in supporting Proposition 64. So what does this mean? This means people with felonies or misdemeanors for cannabis-related offenses that were changed by Prop 64 are now legally entitled to petition the courts to expunge or reduce those convictions. So for example, growing up to 6 cannabis plants was a felony, but now that it's legal, you could have those records completely expunged from your record if you petition to the courts. However, like Nia and Rodney both mentioned, the majority of eligible individuals had not and have not gone through this process of petitioning to the courts, and hundreds of thousands of Californians still live with convictions that could be changed on their records. The Department of Justice estimated that there are 220,000 cases that are eligible to be modified on people's records. So not only are many people unaware of this opportunity that was created under Prop 64, as Rodney mentioned, to change their records, but there are also many people who do know about it but are confused on how to navigate the legal process. I'm not an attorney, and Assemblymember Bonta wanted to know what the current process was, and it was really difficult to figure out. And each county has their own separate rules, so depends on which county you had your conviction in, and they have their own process. I mean, I was even told that if you staple or hole punch some of your paperwork that you submit, that could literally deter you from getting your record modified. So it could come down to little minor details like that. So we wanted to introduce AB 1793, which really put the burden on the state. Hey, we legalized, certain cannabis-related offenses, and so now the burden shouldn't be on the people to have to petition to the courts. It really should be on the state. So since we introduced AB 1793, several local district attorneys in counties like Alameda, Sacramento, San Diego, San Francisco, Sonoma, and Yolo were proactively reducing or dismissing Prop 64 eligible convictions without requiring individuals to initiate the process. However, this is only a handful of counties within California. We know we have 58 counties. So really, it's not fair, depending on the county that you live in, that you may just have this process be automatic. But if you live in another county, the burden falls on you. So what exactly does AB 1793 do? AB 1793 provides relief by requiring the State Department of Justice to search their criminal record database and to identify all Californians who are potentially eligible for record modification. So they have until July 1, 2019, so the bill will take effect this January, so they'll have 6 months to go through their database, find everyone who's eligible, then they'll have to notify the prosecution, the district attorneys, and public defender's offices in your county. This is a list of everyone who's eligible. And then the prosecution is given a year, so from July 1, 2019 to July 1, 2020, to go through each of the cases and decide whether or not they're going to challenge based on the criteria that's in Proposition 64. So if you might be a risk to public safety because of other convictions that you have on your record, other violent criminal offenses, then there is a chance that a DA could challenge your conviction from getting automatically modified. So they have to let the courts know, again, they have a year to review, by July 1, 2020. If they're not challenging, then the courts will move on in modifying the records. One thing that we're going to have to do follow-up legislation next year is the courts don't have a deadline of when they have to modify the records. It was a little frustrating, but they ended up coming out in opposition and were requesting the governor to veto the bill because they were interpreting that they only had a year to modify all the records, which we didn't write the bill that way. We wanted to really work with the courts. We understand that they have a lot of backlog right now, and without funding, it's hard for them to kind of get it together. But we really want to take until January to work with them to figure out what it is that they need in a reasonable time frame for them to have to modify all the records. So right now, I think they're requesting 5 years, but Assemblymember Bonta has told them that's way too long. So we're hoping to find a middle ground to be able to find the appropriate time for that. But Assemblymember Bonta doesn't want it to just go on forever. He wants to make sure there's a deadline and people's records are being modified in a timely manner. I also want to add that, in Proposition 64, the reason why this was a majority vote is because you can still petition if you feel like the state's taking way too long and you do have the resources, the legal resources to do this yourself. You can still petition to the courts to get your record modified. You don't have to just depend on the state to be able to do that for you. So, like I said, this bill really had a strong coalition of support. Many of the folks on this panel were really, really helpful. And moving forward, I think this is a really, really huge start. California, again, is leading the nation. I think since we introduced AB 1793, I think Seattle is also starting to automatically reduce records. So this was a huge win for all of us, but it doesn't stop here. So I really want to have my business cards here. I encourage you guys to please take one if you have any ideas on how we could reduce barriers for people of color, low-income people. I want to hear your ideas. Assemblymember Bonta wants to hear your ideas. And actually, as I've been on this panel here in the last 20 minutes, I did receive a text from my boss that he wants to look at what we did with 1793 and expanding that to other criminal convictions. So really want to hear from all of you. This wouldn't be possible without every single person in this room. So thank you again for having me, and look forward to hearing all of your ideas. Thank you.
Hi everyone, my name is Evonne Silva. I'm with Code for America, and I'm just so grateful to be here. So thank you to Jim and to Nia for the invitation. It's just really such a pleasure. Code for America is a national nonprofit founded about in 2011 with the belief that government can work for everyone, for the people, by the people, and we ought to hold the government accountable to that. And that it can work in the digital age, meaning that we shouldn't have a lower expectation of the services we're provided and that we seek from the government simply because it is the government. The government can actually meet our standards and the standards of the digital age. We have Code for America works in 4 different areas, criminal justice being one, but also health, food, and workforce development. Our work in criminal justice is to transform the way that government is delivering services to those most impacted by the criminal justice system. And in doing so, reinvesting in communities by removing barriers to employment, housing, health, and education. Code for America builds technology. It does really 3 things is what it's trying to do. It's to show what's possible by building and leveraging technology in partnership with government. In showing what's possible, it's also showing that government can think about how it's using technology and user-centered design, what it really means to focus the needs of the constituent in the way it's delivering services, which is a novel idea that government is centering the needs of the people in the way that it's delivering its services. That government can do that for itself and show government how to do so. And then build a movement along the way of individuals across the country who can build digital services, can think about how we can improve government. So in the criminal justice system, thinking about how can we transform the way government is delivering services to those most impacted by the criminal justice system. And for our record clearance work, it's thinking about how do we start to shift the process, rethink the process, shift the burden to the government to automatically clear all eligible convictions available under every statute in California and across the country, and really shift that burden for the reasons that Rodney and Viviana explained. And so Code for America started Clear My Record about 2 years ago, trying to connect individuals with more lawyers, thinking that if we can connect people with lawyers to petition the court to get their records cleared or their convictions reduced, that will help to bridge this gap between those who are eligible and the remedies that are available. But what we found is that there simply aren't enough lawyers. There isn't enough funding for post-conviction, and the wait time is still too long. And not every county has services, so there's a disparity between if you live in a county, whether or not you're able to access services to clear your record. And so we asked a different question. That service still exists. It connects individuals to lawyers in their county across multiple counties. But we asked the question, what if people could do this on their own? And then we asked a follow-up question is, why do people have to do this at all? Why doesn't the government, who holds the data and can determine eligibility in an expansive view, why doesn't the government provide this service on behalf of individuals? And so we've been, I'm fast forwarding my computer, but not this computer. Here we go. So what if we rethought the record clearance process by shifting the burden from the individual petitioner over to the government and draw the line between can't and won't? We've often heard from government stakeholders, criminal justice stakeholders saying, I would love to provide record clearance services. I just can't. I don't have the resources. What if we built technology that provided those resources, that really drew the line between a district attorney who has been saying they can't do it, they don't have the resources, to simply saying they won't do it for whatever reason, because the resources and the technology exists for them to do it. So Code for America built a tool called Clear My Record Automatic, which can read criminal records, criminal data in bulk, determine eligibility under the remedial statute, the clean slate statute, and generate the motion that the DA then files with the court. And then the court can then process that motion quickly as part of the process. And that information then gets sent to the DOJ in a quick fashion as well. And so when we thought about how do we streamline and automate, we were thinking, like, how does this technology actually start to work? And so we wanted to partner, and we have started partnering with district attorneys, and we've launched a pilot earlier this year after DA Gascon had said, look, I'm going to affirmatively clear or reduce convictions eligible under Prop 64. And we asked DA Gascon's office, how are you going to do that? And they said, paper and people and overtime. And we said, well, okay, or we have a technology that allows you to actually clear all of those in exponentially faster pace. And that launched our work. And then hearing about AB 1793, we think about how do we have the policy infrastructure that creates a mandate for every DA to do this. So the idea of clearing 200,000 records isn't far-fetched. We can do it in a year. We can do it in a year. And so this is, you can't actually see this, which is not very helpful, and I apologize. When we are building technology, you have to understand the full process. What is the process that one goes through in petitioning the court, or that a paper moves through a process? And what are the points of friction that we can alleviate, and what are the points that we can actually automate? And so this serves as a blueprint for automatic record clearance through the Clear My Record automatic tool. And it shows the work of the DA, the work of the tool, the work of the courts, and the work of the Department of Justice. And understanding what are those pain points and how do we actually alleviate those pain points. Let's surface them and acknowledge that the court is going to get hit with the volume of petitions, but that doesn't mean it takes 5 years to review those petitions. It just means we need to think creatively about solving that pain point and that reality. And so in May, we launched Clear My Record Automatic, and we are looking to partner with 3 to 5 California counties, particularly with district attorneys and other stakeholders in those counties, to clear and reduce eligible convictions under Prop 64, with the goal of clearing 250,000 convictions by next year. We are wanting to implement AB 1793 using technology that allows DAs, they don't need a year to actually review. We can help a DA review 100 records in under 5 minutes and determine eligibility. That is the power of the partnership between the work of policy change and creating a policy landscape in sync with the technological infrastructure that allows the actual implementation of the law. And so it's great to hear that the courts are now, let's think about how the courts can implement it well within 5 years, which is great. Oops, nope, here we go. This is what the tool is going to look like. Essentially, so the technology exists. We're partnering. We started with San Francisco. Contra Costa has joined our pilot. We are in contract. We've invited San Joaquin and Sacramento to join the pilot, and we'll announce the full cohort of the 5 pilots in October. This is what the tool will look like. Essentially, a district attorney will take in all of the information provided by the DOJ under AB 1793, be able to review all of that information, determine eligibility under Prop 64, and then automatically generate the paperwork that is sent to the court. And we're hoping that we're working with the courts as well to have that electronically sent over to the courts. And so it streamlines that workflow for the DA. So when you think about the bucket that year that the DAs have to review criminal convictions eligible under 64, this is the tool that will help them do that well within that time. So when we think about 7,000 records, it takes an attorney 30 minutes on average to review that record. We can review 100 records in under 5 minutes using this tool. So that is, and there really will be a confetti more. So that is all. Thank you so much for your support.
Just in conclusion, I'd like to say a few more words and just emphasize the fact that, again, this is all about community and community healing. As someone who has been around long enough to kind of pick up on some patterns that happen in underfunded communities, and especially for children, this is extremely important to me, and decriminalization is essential when it comes to the marijuana fight, because if people can't return to their families and their communities, then we begin to lose our community. We begin to lose who we are. And I feel so strongly about, you know, the people that get left behind in this system. So thank you again for our speakers for speaking on this today, and thank you for everyone in the audience for taking the time to listen. And I hope that you leave this panel feeling more educated about this topic and maybe wanting to devote some of your time to it. So on that note, I'll open it up to any questions that we have in the audience for our panelists and to myself in addition.
Thank you. My name is Kemi, and I'm from the National Employment Law Project. We're a worker rights organization, and I have two questions. One, if I understood your presentation about where the source of the records are coming from, that it would be directly coming from DOJ. But one thing that we know is that about 50% of the records are actually incorrect, and so I'm curious as to how you all will reconcile if the input is problematic and how that cascades. And then the second question that I have is that we do a lot of work around occupational licensing, and I'm not as learned on if there are licensing restrictions for those folks who have records, and if again they differ by locality. So if anyone would speak to that, that would be wonderful. Thank you.
Yeah, so to number one, can you explain more on how 50% of them are incorrect?
Oh, just that a lot of what's sourced from DOJ and FBI is just factually incorrect, in part because there might be gaps, like, you know, if someone was arrested but not prosecuted or charged, that arrest record still shows up. And so for those folks who say, for example, are trying to get into the licensed occupations, like that would show up as a barrier. And so they would have to go through this whole process to amend to get that removed, in part because a lot of local police departments don't regularly update their records. So I guess the question is just sort of how do you all reconcile that?
Yeah, I'm wondering, I mean, even for Code for America, because they're specifically looking at if you've been charged with something, so not arrested. But that would definitely be something that we could, you know, meet with the DOJ to clarify. But my understanding is they're just looking at, you know, charged convictions, not based on arrests. Because that's what the 220,000 cases that are eligible, that's not based on arrests. Because I know I've got 500,000 people who were arrested for cannabis convictions. So this was based on charges, but more than happy to have a conversation with the state DOJ to make sure that, you know, the information they're providing to the prosecution is accurate.
As to the second question, I know there are some restrictions written into law that prevent people from accessing occupational licenses. So I mean, that's certainly something that would be changed if they were to have these felonies reduced or to have those convictions completely removed. Some of that is just regulatory, but some of that is actually written into law. And so our hope is that through AB 1793, we're able to help people get the occupational licenses they need to access these opportunities.
Yeah, in the Code for America app, is there any way in the process flow to involve the person that does have a felony? That way maybe you could notify them, and they could be the person that can help clean this up, right? But that was the only piece, that very cool application, the only piece missing is that if I'm that person that whose record is being cleaned up, it'd be awesome to be involved in the process and notified, right? So I can make those corrections.
I think that's her question, basically, of how they'll work out.
Yeah, the question of how to notification of that this process has happened is a question we're actually trying to explore and answer because of the and either of you might have answers to this, because of privacy concerns, so that we're both privacy concerns and access to the most accurate contact information. What we're finding is that many of the government stakeholders say, well, I don't have the most recent contact information, and we don't want to send a notification to the wrong person. And so if you have any ideas around notification, we're actively trying to think through what that looks like. And it may just, and we don't quite know what it looks like. for the tool that Code for America had built at first was initiated by the individual with a criminal record to connect them with public defenders and legal aid, to get an attorney to help them file the petition. But the scale and volume, folks are under-resourced and don't have the capacity to help at the highest volume necessary. And so when we shift over to the government to automatically do this, when they do that, how is the notification sent out? And so, you know, it could be that the public defender does it, but even the public defenders have said we don't have most recent contact information. The courts might be able to, but maybe there's the courts talking with the DMV and there's a cross-reference. And so trying to figure out what that actually looks like is a live question, yeah.
Any other questions?
Yeah, my name is Juan Bautista. I'm from Opportunity Sprawl. My question would be, how will this help out minors also after, let's say, they turn 18, and let's say they're trying to get their life together, trying to go to college or whatnot? Will this help them out in their way, or they have to wait till they're 21? How does that work? And my secondary question would also be, will violations be put under that too? So like, let's say someone's smoking weed and they get caught up for violating for that, is that considered also part of this law?
Sure. So people under the age of 18 are now no longer being charged with marijuana misdemeanors or felonies. Instead, they're just receiving infractions. And so there is a process for minors to petition the courts to also have their records changed. But one great thing about Prop 64 is that people with these prior convictions that got these convictions before they turned 18 will have them automatically removed from their records when they turn 18 or 2 years from the date of conviction, whichever of the two comes first. So that problem was really thought through with Prop 64, so hopefully those folks do get the relief they deserve there. But beyond that, there are still some penalties for smoking in public, for example, but that's a civil violation. It's a fine, but it would not necessarily affect that person criminally. But of course, too, I think there's work to be done to reduce those fines even, because I mean, a $200, $250 fine is obviously far too much for most people. So there are efforts there being made to, reduce fines, but that's the point at which we're at.
Okay, but I'm talking about a 90-day hold. People getting arrested constantly for smoking, right? And whatever it is, recreation. They're not even arrested for marijuana, but they're constantly being put back in jail because they're smoking marijuana. They're constantly getting 90 days or 180. How would this law work under that too, or would it's also constantly just because it's still felony probation or whatever, you just can't smoke?
I mean, there are other restrictions, and I think Prop 64 doesn't reach every circumstance, but I think, cops may sometimes use that as a basis to search someone, the smell of marijuana, which is obviously something, it's a legal substance to contest now, but, cops will still use that, and maybe they find that the person has something else, or they, initiate an illegal search. But, I mean, those are problems that we obviously want to work through, but something that Prop 64 didn't address specifically.
Rodney, I'm just going to jump in and ask a follow-up question. So one thing I get to figure out in Prop 64 is, like, if a young person who's under 18 gets an infraction, right, and then has to go do community service and drug education, who runs those programs and where does the money come from to run those programs? Do you know that one?
I'm not sure where the money's coming from, but I think it's a county-to-county sort of situation. So I think counties regulate that in very different ways. But as far as the source of funding, I'm not certain. Yeah.
I have a question about, is there anything being done in regards to people who are on probation and drug testing around 64? Because it really doesn't make sense to further criminalize people who are on probation for smoking marijuana. So is there anything being done around that? Is there a process?
I wouldn't say a process exists necessarily. I know people who were on probation when Prop 64 passed were able to petition to be let off probation through the resentencing provisions, so that definitely exists. As far as a person still receiving additional penalties for smoking while they're on probation for maybe another offense, I mean, that wasn't really changed by Prop 64. I think there's still lots of...
Is that going to be challenged in the future, do you know?
I really hope so. I think that's something we definitely want to explore, but as far as Prop 64 is concerned, no, that wasn't something that changed under Prop 64.
I have a question on the clean slate statutes. I'd like to find out how deep that goes. Is that just for cannabis, or is it if they started out with a record for cannabis and then they got deeper in trouble, do they get help for that too?
So yeah, clean slate is pretty expansive. It can, and this existed prior to marijuana legalization here in California. So a person that has a conviction, for burglary or for just another offense may be able to petition the court to have that conviction dismissed. So it works for lots of conviction types. Some are excluded, some of the most serious offenses, but for all others, there are often remedies available for folks.
Hi, Rodney. I have a question. So are you guys working on the policy where we can have legal consumption spaces or even can still consume outside because there's nowhere for us to consume? Or how's that looking? Because we can't do it in our cars. If you live in government-funded places, you can't do it there. So where are us African-American people that don't own homes supposed to smoke?
No, that's still a huge issue, and it's a national issue, really. People aren't able to consume in public housing, and that forces them to go outside or into their cars, which is also illegal. And then in those spaces, they may be arrested or fined. That wasn't included in Prop 64, but I know there is growing interest in helping to mitigate some of those horrid effects, because yeah, people can be kicked out of public housing just simply for possessing. So you know, the efforts are definitely there, but it's going to obviously require everyone in this room like fighting that good fight, because you know there's so many different parts of this that still need to be repaired.
That was actually my question.
Oh, okay.
So, yeah, thanks.
Hi, I'm curious about if you lose your job by taking a required test, you know, and they find marijuana, and then you're working for the company already, but then you're going to be promoted and you have to take a test and then they fire you afterwards. Is there any provisions for that?
Unfortunately, no. A person could still be fired if they're asked to submit to a drug test and their employer doesn't want their employee using cannabis. So that's still an issue, and that's something that many different groups across the country are working to change. But yeah, it's still an issue. It's a bad one, and if anyone's an employer here, we hope that you don't drug test your employees. But yeah, that's still an issue that's being faced here in the state and across the country.
And I'll add that Assemblymember Bonta introduced Assembly Bill 2069 this last year. Unfortunately, the bill was held in Assembly Appropriations Committee, but it was starting for patients. So if you have a medical ID card or recommendation that your employer would have to reasonably accommodate you taking your medicine for however long you need to, or if you have your card indefinitely, but they'd have to have that conversation with their employee and wouldn't be able to fire based on their patient ID status, or basically treating it like they treat opioids and other medication, right? Yeah, unfortunately that was held, and that bill was just specifically targeted toward patients, and we couldn't even move that forward this year. So I'm hoping we'll reintroduce that again this year. We're trying to do some of the background work, and then hopefully eventually we'll be able to move that along to not just patients, but for adult use too. So definitely going to need all your guys' help on that effort, because it's not an easy one.
I have a question to pose, and this is one that I always forget, so please help me clarify. What is the difference between Prop 47 expungement and Prop 64 expungement? I know that they both serve the same purpose, but depending on what particular felony or misdemeanor you have, there is a different order of operation. So could you please explain, if you could?
Sure. Prop 47 deals with a different set of crimes than Prop 64. Prop 47 covers the possession of other illicit substances, and really illicit substances, but also crimes of poverty, so petty theft and those sorts of things that don't amount to anything above $950. That's what Prop 47 deals with. But the difference with Prop 47 especially is that it only really allows for the reduction of felony to misdemeanor. It doesn't include provisions that allow people to have their convictions completely removed, like Prop 64. So with Prop 64, we know that some activity in the state of California was made legal, like cultivating up to 6 plants or possessing up to an ounce of marijuana. So there is a pathway for you to completely remove prior convictions relating to those offenses, but Prop 47 is merely a reduction from felony to misdemeanor.
Thank you.
Hi, I have a question about Los Angeles. What percentage of the eligible convictions do you estimate are in Los Angeles County alone? And how are Code for America's discussions with Jackie Lacey's office going?
I don't remember the exact number, but I know Los Angeles has the majority of the convictions in their county, and we were a little surprised but very happy that District Attorney Jackie Lacey actually supported AB 1793 and was also, actively encouraging the governor to sign. So.
And we've been in productive conversations with DA Lacey's office, in part because the Board of Supervisors in LA has asked both the district attorney, the public defender, the courts, and the various offices of cannabis management to come together to figure out how to bridge the gap in terms of those who are eligible in LA County and those who've actually petitioned the courts, and the numbers are pretty low. So statewide, less than 3% have petitioned to have their records cleared under 64 or reduced. So there is, the conversations have been positive, and the efforts pushed and the sort of atmospherics of the Board of Supervisors has been helpful in that regard. It also, to the point of those conversations have been held because of resources, has been the sort of talking point. We don't have the resources to do the thing that you're asking us to do, and AB 1793 creates the infrastructure. It's a mandate that they actually have to do something. And the Clear My Record, our tool, the service that we're providing, actually is the tool that enables them to do it. So there's nothing left on the table except that they are choosing not to do it. But the conversations have actually been quite positive. So we shall see.
Any other questions from the audience? Yeah.
I'd like to ask a similar question about Sacramento County and how you've been working with Anne-Marie Schubert and the Board of Supervisors there, and what we can do if there are barriers to that conversation as a community to encourage this.
Nia, do you actually want to talk about the efforts in Sacramento?
I'm sorry. I'm from Sacramento. Oh, hello. Hello. So I was wondering about Code for America's program and how the conversations with DA Anne-Marie Schubert and Sacramento Board of Supervisors is going, and how we as a community can help, encourage them to adopt this.
Awesome. I can tell you guys all